Perfect.
Okay, thank you.
All right. I guess we'll go ahead and get started. I'm Liz DeVille with the Economic Development Alliance, or the Chamber Southwest. And I would like to now introduce Kellen Matthews with Adams Reese. And he is the co-host of Understanding the Paycheck Protection Plan.
Thanks, Liz.
All righty.
And thanks to George and the Alliance. Like Liz said, I'm Kellen Matthews. I am the partner in charge of the Baton Rouge office of Adams Reese, and a Lake Charles native. So glad to talk to some folks from back home. My practice is primarily litigation. I do a fair amount of labor employment and also mostly state procurement work. On the panel, I have Michael Burson, who's in the field office as well as DC, who specializes in SBA-related issues. Michael was previously Director of Governmental Affairs and Associate General Counsel of the National Small Business Association in Washington, D.C. And we also have our partner, Greg Rochelle, from the New Orleans office, the Labor and Employment Team Leader, and he's a critical piece of our COVID-19 task force, who's been on the leading edge with getting out all the information that's coming fast and furious out of Washington in response to this pandemic. And today we're presenting a little bit more about the Paycheck Protection Program, which is part of the big CARES Act that was passed here a couple of weeks ago. Both Michael and Greg are going to discuss how the latest guidance that we've gotten provides some additional direction with respect to the Paycheck Protection Program, which you probably have heard referred to as the PPP, as well as how the Department of Labor guidance has given some additional background with respect to how the Family First Coronavirus Response Act measures are playing out. Really briefly, I mean, I'm sure everybody's familiar with the CARES Act. It's a $2 trillion program that includes the PPP, which is it features a loan forgiveness program, which Michael's going to tell you about, provides for $349 billion in aid for small businesses. And it works prospectively. It works with your anticipated needs for payroll. So it's a little different than the normal SBA process. So with that, Michael is going to go and walk us through how the PPP works. Michael?
Thank you so much, Kellen, and thank you everyone for the opportunity to present to you today. And what we're going to do is we're going to kind of just give a broad overview of the program and then go into some of the specifics regarding the criteria. And then what's most important about this program that's probably going to be of most interest to folks is the forgiveness aspect of it. So the Paycheck Protection Program is a program that's being run by SBA. It was included in the last bill in the amount of $349 billion. It provides businesses with unsecured loans that are intended to cover their payroll and other expenses, and I'll get into the specifics of their payroll and what expenses are permitted. The effective time period for this is February 15th, 2020 through June 30th, 2020. These are 100% federally guaranteed loans. Unlike the EIDL program, this program you actually apply directly to your lender, so your lending institutions, your banks, your credit unions, and other approved lenders. The EIDL program is run and you submit those applications straight to SBA. One thing to point out here is essentially the effective date of February 15th, 2020. So they've made this program retroactive. The objective of the PPP program is to keep as many employees on the payroll, or if you've unfortunately had to lay off employees, bring those employees back on. And if you do bring those employees back on, you are still able to avail yourselves of the benefits of the PPP program. So discussing now a little bit regarding eligibility. The program is generally open. It's available to those small businesses who were already permitted to participate in SBA loan programs prior to the COVID pandemic. This is all business concerns that employ less than 500 employees as of the effective date of February 15th, 2020. Under the PPP program, also 501c3 nonprofits that employ less than 500 employees are also eligible. We've gotten a couple of questions of whether any other 501c designation entities are eligible. There's just one right now. It's primarily focused on the veterans organizations. But those are the two really only 501c3 type of entities that are eligible. This also applies, and I want to point this out, to certain industries that don't necessarily fall within those categories. What they did in the bill is they provided an exception for industries that employ more than 500 employees, but there are no more than 500 employees at a given physical location. This is for those industries whose NAICS code begins with 72, which is generally restaurants and those in the food service industry and hotels.
Michael, is that a little bit different than the normal SBA guidelines with like the revenue caps? How does that apply, or does it in this situation?
So the exclusion that they made was specific to those industries. So it's those are the only ones where there are issues coming up with the number of employees, and you're talking about full-time employees or headcounts. Those are the only ones that are going to be permitted to use that type of exclusion. So it does not apply to those in the transportation industry, for example, or others.
Thank you.
So discussing generally the criteria of the loans, these loans are capped at the lesser amount of $10 million or 2.5 times your average total monthly payments for your payroll costs. And they're going to compare that to your previous 1-year period before the loan is made. Originally, when the bill came out, interest was capped at 4%. Then subsequently thereafter, Treasury said it was going to be 0.5%, but as of April 2nd, that number is now and is fixed at 1% interest. So another few different aspects of the criteria that I think are going to be very important to point out and will be of interest. Loan payments are automatically deferred for at least 6 months, but cannot be deferred up to a year. That's how it read in the original bill. Since then, SBA has come out and said that really it's only a 6-month deferral. So they're holding pretty firm on that. That may be subject to change, but as it currently stands based on the interim guidance that we've received, it's just a 6-month deferral. Unlike your traditional SBA loans, such as your 7As, your traditional 7As that is, and 504s, borrowers do not need to establish that they are unable to secure credit elsewhere. So just for background purposes, the credit availability elsewhere test has been around for a long time, but that term has essentially evolved internally at SBA, such that originally when it was implemented, the SBA would require a denial letter from your bank to allow you to satisfy that particular test of unable to secure credit elsewhere, the credit availability test. They have done away with that as well. In addition to that aspect of it, SBA has also done away with the need to establish credit worthiness and the ability to repay, which is a huge question that a lot of folks had initially about how this program would look. So really the relevant inquiry that SBA is going to make is whether you were in business on that effective date of February 15, 2020, and were you paying employees at that time?
Thanks, Michael. And I know one of the big topics that people are asking about is the acceptable uses for these loans. Can you tell a little bit about the uses and the payroll costs in particular?
Sure. If you go to there you go, acceptable uses. So I'll speak generally as to the acceptable uses, and then I'll kind of go to a little bit more specifics. But so it's payroll costs, group healthcare benefits for the relevant period of time. So that's paid sick leave, medical or family leave, and this includes insurance premiums. Other aspects of employment compensation, your mortgage interest payments, but only if that mortgage was in place prior to the February 15th, 2020 date. Your rent, but only if that lease is in effect prior to that effective date of February 15th, 2020. And utilities, but those utilities had to have been in place and on essentially before that February 15th, 2020 date as well. Some notable exceptions I do want to make sure everybody's aware of. This excludes withholding taxes, sick leave that is already provided for by the Families First Act, which Greg is going to discuss here in just a few minutes. And then individuals making more than $100,000 per year. So essentially what you're able to do is you're able to include the compensation up to the $100,000 mark, and then everything after that or above that is going to be excluded.
Okay.
So the loan forgiveness aspect of it is of course what makes this PPP program so attractive when compared to various other programs, whether they be the EIDL program at SBA or other programs. Generally speaking, the amount of the loan forgiveness cannot exceed 100% or may not be 100%, excuse me. The items that SBA is going to include in that forgiveness amount is going to be the payroll costs during the 8 weeks following the loan origination date, mortgage interest, but again, only if that mortgage was in place prior to February 15th, 2020. The rent, but only if that lease was in place before the effective date, and then utility payments as well. We anticipate SBA to issue additional guidance on the actual loan forgiveness aspects of this, including what documentation is going to be provided essentially on the back end of this. We're not exactly sure the timing of it, but we have been told that it is forthcoming. So we should have some additional clarity on exactly how the loan forgiveness calculations and the documentation that's going to be required for that will play out. Another thing that is really important to mention about the loan forgiveness aspects of it and what could potentially reduce the amount of loan forgiveness that you're afforded is if you reduce your workforce headcount during the relevant period, and they're going to be comparing that to the last the same period over the last year. But if you've laid off employees, it's important to note you will not be penalized if you bring them back on. Similarly, you are going to be penalized, although we don't know exactly how that's going to be weighed yet, if you reduce the employee's compensation during that relevant period, and they're going to be comparing that to the relevant or the same period last year. So as an employer, you're going to be required to fill out certain paperwork. And again, we're going to get some additional guidance and clarification on exactly what that paperwork is going to be in order to facilitate the loan forgiveness aspects of the PPP program. But one thing to note is that any amounts remaining after the forgiveness must be repaid no later than 2 years after being borrowed. Originally, the legislation provided for up to a 10-year term. SBA has limited that to 2 years as of the guidance we received on April 2nd. And the real reason behind this is that they want these loans to serve as essentially bridge loans. They want them to be focused on keeping employees on the payroll or bringing employees back on who've been off. And then that's something else I want to mention is that pursuant to the guidance that they recently issued, no more than 25% of the loan proceeds can be used for those other expenses. Essentially 75% of the proceeds has to be used for your payroll expenses. 25%, no more than 25%, excuse me, can be used on the interest on the mortgages, the rent, and the utilities.
Right. And Michael, I know there's lots of different scenarios, and we're not going to obviously get to all of them in this situation. But can you talk a little bit about the headcount calculation as far as the part-time employees versus full-time employees versus other classifications?
They're working on. We're actually seeking a little additional guidance and some clarity on those. So there are a couple of questions around it, but we should hopefully have some insight on the answers to that question soon.
Right. And I know one thing that's, I know Greg will probably definitely weigh in on this. One thing that we definitely need to know that 1099s are obviously not included for this because they're by definition not employees. They're independent contractors. And there could be additional classification issues. It could have other ramifications, but that's something that definitely wouldn't include your payroll calculation.
That's correct, Kellen. So on April 3rd, the application period opened for small businesses and sole proprietors. April 10th, it opens up for independent contractors and self-employed. So they've made a pretty hard distinction between independent contractors and making sure they're not included in that employee count for purposes of payroll and the actual loan amount. So thank you for mentioning that. And now I will turn it over to Greg to address other aspects of the CARES Act and kind of the interplay between PPP and those provisions.
Thanks, Michael. Many of you who are listening here probably remember that before this SBA loan program passed in Congress, there was actually another law a couple of weeks prior that dealt with mandated paid sick leave. And that was part of the Families First Coronavirus Response Act. And what a lot of employers did in response to that law that was going to require them to pay their employees paid sick leave for certain COVID-19 reasons, they decided, okay, the law doesn't go into effect until April 1st. So what I'm going to do is I'm going to lay everybody off so that I don't have to worry about complying with this law. Or I'm going to furlough everybody, tell everyone to stay home without pay, and instead direct them to go seek unemployment compensation benefits through the state. Because another key component to all of this is that state unemployment compensation funds are being infused with millions of dollars of cash right now. And so you have two options as an employer, everybody understands. You can avail yourself of the Paycheck Protection Program, which is essentially going to provide you with an 8-week bridge loan so that you can continue to keep people on the payroll at full salary for the 8 weeks after you get the loan. That's the congressional intent. They want you to hire people back and keep them on the payroll. But if you hire them back, that necessarily is going to mean that you now have to worry about the paid sick leave obligations again. And I just want to make sure that, you know, everyone realizes maybe these SBA loans are not the solution for you and your particular business. It's an individualized assessment as to whether or not it makes the most sense for you financially to take out the forgivable SBA loans or just remain shut down and hope that your employees qualify for unemployment benefits. You know, some businesses are not allowed to operate right now. For example, bars, restaurants. So a lot of employers, these small businesses, they're scratching their heads and they're saying to themselves, well, I take out this SBA loan, and what that is going to mean is that I got to rehire everybody back and I pay them their full salary, but I can't run or operate or turn a profit right now. So it really doesn't make any sense for me to do because I don't want to have to deal with the headache of paying people, filling out this paperwork, reconciling it so that I'm sure I don't have a loan balance, using it for acceptable uses. So some people are going to opt not to participate in this, and that's okay. There's other avenues for your employees to seek benefits, namely unemployment through the states. But if you decide that you are going to take advantage of the Paycheck Protection Program, I want to make sure that everyone understands a few rules. The first rule is that you can't use the money you get from the SBA to pay the mandated sick leave. Options for seeking reimbursement for any paid sick leave that you're required to pay due to COVID-19 related leaves of absence for your employees, you get reimbursed in the form of tax credits. And what the Senate did recently with this bill that the House passed is they sort of cleaned up how this tax credit issue is going to work. They did two things, and I'm going to get more into this on the next slide, but they did two things to sort of make these funds immediately available to you, and we're going to get into that in a minute. I want to encourage all of you, if you have not done so already, to visit the Department of Labor's website, because there's a ton of useful information. Q&A, common questions and answers with various scenarios of what you're going to be required to administer the paid sick leave. They also have, excuse me, they also have fact sheets. You're going to have to post required posters at work, just like your workers' comp poster and the other posters that you have probably in your break room, your lunchroom, or your copy room. Have the required posters on their website. So I would encourage everyone to visit the DOL's website, because there's lots of useful information in there. I think we can go to the next slide, Kellen. So here's how these tax credits are going to work, and I want to make sure everybody realizes. What they did was, and it was sort of clever in a way, they said, okay, employers, you have to pay quarterly payroll taxes for your employees, U.S. Treasury, every quarter. What we're going to do is we're going to put in a provision here that says IRS penalties for failure to make your quarterly payroll deposits are waived. They're not going to impose the penalties. At the same time, Congress said we're going to make these tax credits immediate and provide for an advance on the tax credits. So what the net effect is Congress is telling you somebody has to go out on paid sick leave. You're strapped for cash. We get it. Use the money that you were going to use to make your quarterly payroll deposit. Use that instead. Don't pay us, pay your employees. And so that's going to give you immediate access to cash that you otherwise had earmarked for your payroll deposit. You can now use that money to pay mandated sick leave. I also wanted to make clear, and I think we've hammered this point home, that separate and apart from the normal wages you're going to be paying employees pursuant to the Paycheck Protection Program. In theory, you hire everybody back, everybody's able to work, is back in action, you are paying them pursuant to these SBA loans, the principal balance is being eroded and forgiven as you make payments. And in the event one of your employees gets sick, even though they lack the ability to work, and they have to remain home for a variety of reasons, let's say they test positive for COVID-19, they're going to have to stay home for 14 days, most likely, pursuant to a doctor's order. At that point, you're not using PPP money to pay them, you're using paid sick leave money to pay them. And the way you get reimbursed for the PPP money is through the tax credits. So it's going to be really important to navigate all these issues in the right way. Because what I don't want to have happen is for folks to mistakenly use their PPP money to pay sick leave and then find out on the back end of this that part of their loan is not forgiven because they didn't use that money for an authorized purpose. So it's going to be really important if somebody has to go out on paid sick leave that you use the money that you would have used for your quarterly payroll deposit as the source for that cash. And that will ensure that you get the tax credit. It will ensure that you are going to get reimbursed, or I say have your loan, quote unquote, forgiven in its entirety because you followed the rules and stayed within the parameters that are provided for by the Paycheck Protection Program. Next slide. A couple of other things I wanted to point out about the CARES Act as it relates to paid sick leave. As I stated earlier, a lot of employers said, I'm going to just lay everybody off. I'm going to have to deal with this. I can't run. I can't operate. It's just going to get laid off. Well, the Paycheck Protection Program says, if you hire everyone back, we're not going to penalize you. Michael talked about that earlier. hire everybody back and you pay everybody at full salary, what they would have otherwise made, no COVID-19 pandemic, we're going to give you a pass and you're going to get your loan forgiven. Don't hire everyone back, you're going to be penalized. And Michael talked about that. One thing I wanted to point out is that anyone you hire back is entitled to that up to 12 weeks of expanded FMLA leave in the event they have a situation where schools are closed due to COVID-19 related reasons. I think we can all agree that all schools across the entire country right now are closed due to COVID-19 related reasons. If they do not have somebody who can watch after their child because of the school closure, they are going to be entitled to paid sick leave under the expanded FMLA. And I'm sure people keep that in mind too when evaluating options as to whether they want to hire people back or not. That expanded FMLA leave, the first 2 weeks is not paid, but then the remaining 10 weeks is at 2/3 the employee's regular pay or minimum wage, whichever is greater. So just bear that in mind. The other thing I wanted to mention is that they added in the CARES Act a provision at the end, sort of snuck it in. Nobody really paid any attention to it. But Secretary of Labor now has the same authority that agency has under the Fair Labor Standards Act to conduct investigations and to conduct audits. All this paperwork is going to be really important for purposes of establishing that the paid sick leave was granted, a legitimate request, and you used the payroll deposit money properly to pay those employees. It's unfortunate that in times like these, certain individuals take advantage of the system, they get the system, they engage in fraud, and I think a big component of this when all the dust settles is DOL is going to investigate to make sure that things check out. So it's going to be really important to maintain the proper documentation. To that end, the DOL came out with an interim rule actually on Monday. I apologize. The days are all merging together at this point. Out with an interim rule that sort of explains all of the things that I've just been talking about with regard to paid sick leave. And one of those rules that is now in the Federal Register and is available on the DOL's website, it delineates what sort of documentation and information you should be tracking to make sure that your paid sick leave requests are properly documented. It's not that cumbersome. It's pretty easy, actually, but I would encourage everyone to take a look at that as well. So that's it for my end, Kellen. If you have any questions, I'm happy to answer them. But otherwise, I'm done.
Thanks, Greg. I did have one question. I'm sure you can answer really quickly. We have a question that says, do employers that have less than 50 employees have to pay expanded FMLA leave?
Yes, the answer is yes.
Right.
There's a great deal of confusion out there. As many people think that if I have fewer than 50 employees, I'm exempt from this new law. That's not true. The law applies to anyone with fewer than 500 employees. However, there is an exception for small businesses of fewer than 50 employees if basically the business is going to go out of business if it's forced to comply with this paid sick leave law, meaning I don't have enough money in my quarterly payroll deposit account or the operating account. There's literally no cash, and I'm going to go bankrupt if I have to pay mandated sick leave. So that's going to be an individualized assessment for each employer, and you're going to have to establish to the Department of Labor that you truly lack the financial resources in order to comply with the paid sick leave law. And if you had complied, you would have basically gone out of business. I think the burden has been increased greatly for small businesses to establish the economic hardship exception for fewer than 50 employees by virtue of those new advanced tax credits. All your money that you have, dovetailed or earmarked for your quarterly payroll deposits, that's available to you now. So unless you've completely exhausted your payroll deposit funds and you have no money in the bank and you don't get an SBA loan and it's like it's so dire that you're spiraling out of control, I think that hardship exception is going to apply to many people.
Thanks, Greg. That wraps our presentation. I want to thank everybody for joining the webinar. I have received a question, and I'm going to share with George, and he can share the PowerPoint slides that we presented today. And obviously, they'll include our contact information, so you can reach out to us. It sounds like the theme throughout, though, should be document everything. If you choose to go that route, or if you are to pay the leave, like Greg talked about. We're here to help, so feel free to reach out if you'd like to discuss anything specific. And everybody stay safe and stay healthy.
Thank you.
Thanks, guys.